Hello everyone and welcome to yet another webinar by Royal Cyber. Our topic for today is US privacy law updates, what you need to know in 2021. My name is Pratik Nilkund and I'll be your speaker for today. Just some housekeeping before we get started. If you have any questions during the presentation, please type them in the chat window and we'll address them towards the end of our presentation. Also, if anyone is not able to view my screen, or hear me properly, kindly notify me in the chat window. Now, before we start, I want to talk about a little bit about Royal Cyber and today's agenda. We are an IT consulting and digital transformation company, and since 2002, we have successfully completed over 1,500 projects for 600 plus happy clients. We have gained significant recognition from our customers and partners worldwide over the years, including some Fortune 500 companies for providing best-in-class services and solutions across multiple domains. As we speak, we are a team of 1,000 skilled resources globally distributed through various delivery centers across the globe. We are headquartered in the United States with offices in 9 countries across the globe, through which Royal Cyber provides reliable and high-performing governance, privacy, commerce, cloud, analytics, mobile, and middleware solutions and services. We offer end-to-end services right from assessing as a state and the design of current implementation to identification of value-added use cases. Thereafter, we develop and prioritize implementation and expansion roadmaps, explore custom integrations, and finally provide training and rollout assistance. All right, so this is how the agenda looks like for today. We will walk through at a very high level some key US privacy trends in 2021. After which, we will be taking a closer look at the privacy acts that shaping US privacy landscape, namely the Virginia Consumer Data Protection Act. Thereafter, we will go through some general best practice guidelines to consider when operationalizing privacy in organizations. Um, we will then sum up the webinar by answering some of the questions we received today during the webinar. All right, so let's get started. So just a small disclaimer here. We are not lawyers and are not offering legal advice on any questions pertaining specifically to GDPR, CCPA, CDPA, or any other regulation, as well as being compliant with those regulations. Consult your own privacy experts and legal counsel. We help in operationalizing regulations, leveraging real good partnerships with leading tools in the marketplace like OneTrust, Big ID, Collabra, and Informatica. So we have identified some key trends we believe that will define the world of privacy, if not already defining. So let us look at some of the not a matter of if, but a matter of when pointers. Well, this is a big one. The call for a federal data privacy law grows louder, right? So state privacy laws create new and significant business challenges, especially for organizations with widespread operations. So in order to avoid a mix-up of data privacy laws, which would in turn drive higher compliance costs and could slow business growth substantially, it's widely expected that there will be an increased push towards a federal privacy law. So the struggle to comply with this stringent privacy laws across geographies and industries has in a way put a strain on many data privacy and compliance teams. right? In addition, we know that the cost of compliance has also increased significantly. So choosing a unified enterprise-wide data privacy strategy is something that is increasingly being looked at, and it does require significant research and resources upfront, but once implemented, it can significantly reduce future efforts. And this is exactly the route most companies are looking to take. Well, no company, no organization out there wants to be guilty by association. So there's heavy focus, on third-party risk management, risk assessment, and demands on suppliers, vendors, and partners to also demonstrate compliance. Um, cannot stress enough, how important transparency has become for organizations, especially B2C companies, because consumers, with every passing law, consumers are being more and more aware of their rights and the dollar sign that stands next to their data. So trust will not be a nice to have addition to businesses, but a must have. All right, so this brings us to Virginia Privacy Act. After having a glimpse of some of the important trends out there, the Virginia Consumer Data Protection Act, it became law in Virginia last month. And if we are to talk about scope, it applies to organizations that conduct business in Virginia, or produce products or services that are targeted to residents of Virginia, and that during a calendar year control or process personal data of at least 100,000 customer consumers, right? So that's a significant higher jump if we compare it to CCPA, which took into consideration 50,000 custom consumers, but CDPA is at at least, it says at least 100,000 consumers, and it controls an organization that controls or processes personal data of at least 25,000 consumers and derive over 50% of gross revenue from the sale of personal data, right? So one important point to note here, and is that CDPA does not consider annual revenue, and with the threshold of 100,000 consumers, it seemingly limits its applicability to fewer businesses than CCPA, right? So uh, and the applicability is further reduced with when we look at some of the exclusions of CDPA, which are certain government agencies or financial institutions subject to GBLA, um, covered entities or business associates governed by HIPAA, non-profit organizations, and institutions of higher education. The CDPA, by the way, also exempts certain data, including data that's protected by federal laws like HIPAA, again, GLBA, the Fair Credit Reporting Act, the Driver's License Protection Act, and the Family Educational Rights and Privacy Act. So a lot of exclusions and exemptions out there, and a lot of financial institutions and healthcare players will be relieved to see that a lot of accommodation has been provided here, right? So let us here look at the rights within the CDPA, and very similar to CPRA and the GDPR, consumers have some rights. So let's look at these rights one by one. So consumers have the right to confirm whether a controller is processing the consumer's personal data and obtain access to such data. So uh, obtaining access of data was very similar to is very similar to CCPA, but a point of differentiation here is consumers have the right to confirm whether controller is processing the consumer's personal data, right? So this is a small addition here. And personal data, again, is defined as any information that is linked or reasonably linkable to an identified or identifiable natural person. So that's a definition that's been provided of personal data within the CDPA, and it publicly available information is also excluded in this case, right? So that's the first one, which is excess personal data. Correct inaccuracies, and interesting one, not a part of the CCPA, different from the CCPA. And a point to note here is that organizations that are already bound or that have to comply to CCPA will have to make a modification or an addition to the workflows that they already have, right? Which is to correct inaccuracies, right? Consumers have the right to correct inaccuracies in their personal data. So that is an interesting right here, and it's kind of borrowed from the GDPR. Then there is right to delete as well. Consumers have the right to delete personal data provided by or obtained, about him or her. So right to data portability is the next one on the list. It you know pretty straightforward, where consumers have the right to obtain a copy of the consumer's personal data in a portable and readily usable format. Again, very basic kind of a right. And then the last one is the right to opt out of certain data processing. So consumers here will have the right to opt out of the processing of personal data for purposes of targeted advertising, the sale of personal data, or profiling. So one relief, if you look at this point, there was a lot of confusion around the term sale, where when we spoke about CCPA, right? But here it's defined more narrowly than under the CCPA or CPRA, to mean the exchange of personal data for monetary consideration by the controller or to a third party. So just that really helps, because it's a very simple definition now. And the CDPA does not provide any hardship exemptions to these rights. um, Businesses must respond to requests within 45 days of receipt of the requests, and may extend where reasonably necessary for an additional 45 days if the consumer is notified within the first 45-day window. And also under CDPA, business must also establish procedures for consumers to appeal a failure to act on a rights request within a reasonable time period, and inform consumers of how they can submit a complaint to the Attorney General if the appeal is denied. So this is again an interesting point here, to establish procedures for consumers to appeal a failure to act on a rights request. And um, you know um, also the onus is now on the organizations to kind of give out that map of how they can submit a complaint to the Attorney General if the appeal is denied, right? So very interesting last point here, or last right there. So now let us look at some of the key obligations for controllers. As CDPA places several responsibilities on controllers, including data minimization or limits on collection of and use of data. Right, so CDPA requires that controllers kind of limit the collection of personal data to what is adequate, relevant, and reasonably necessary for the purpose for which the data is processed, right? So there also needs to be reasonable security, which means that controllers must now implement and maintain reasonable administrative, technical, and physical data security practices to protect the confidentiality, integrity, and accessibility of personal data. So such protections should be appropriate to the volume and nature of personal data at issue. Controllers are required to also obtain the consumer's consent before processing any sensitive data. So, and if you are confused, or if you want to know what consent is here, it's defined very similarly to the GDPR and the CPRA, right? So no surprises there with the definition of consent. Um, um, CDPA also requires that controllers enter into data processing agreements with their data processors. So these agreements must clearly set forth instructions for processing data, and this the CDPA provides specific terms as well that must be included in any data processing agreement out there, right? So uh, more or less, the privacy notice is similar to the requirements for privacy policies under CCPA, and to a more limited extent, under the GDPR, controllers must provide consumers with, a meaningful privacy notice that includes a the categories of personal data processed by the controller, b the purpose for processing personal categories of data, right? Um, C, how consumers may exercise their consumer rights, and D, the categories of personal data that the controller shares with third parties, and most importantly, the categories of third parties itself. So this is again, very similar to CCPA, but may require some modifications, but not a start from scratch kind of an exercise here. Uh, Notice of sales. So customers, or sorry, controllers that sell personal data to third parties or process personal data for targeted advertising must clearly disclose such processing in its privacy notice, and provide a manner in which a consumer may exercise his or her opt-out right. So this is again very very important, and we discussed the consumer rights on our previous slides, but one thing we did not discuss was about controllers must establish one or more secure means for consumers to submit requests in the first place to exercise their rights, right? So the controller should be able to authenticate the identity of the consumer making the request as well. Um there must be an assessment, or must conduct and document a data protection assessment for certain processing activities, which includes the sale of personal data, the processing of personal data for purposes of targeted advertising or profiling, the processing of sensitive data, and any processing activities involving personal data that present a heightened risk of harm to consumers. So it's very necessary to conduct this assessment and document this data protection assessment, so that in just even from a logical standpoint, even if there is kind of a security breach, then we can narrow it down to these processing activities first, and then look at them in greater detail. So very logical kind of an obligation here. uh, so the enforcement date for the CDPA is January 1st, 2023. Uh, Violations have a 30-day notification period to allow the controller processor the opportunity to cure the violation, and if there are any uncured violations, then there is it's subject to action seeking $7,500 per violation. So that's again very consistent with CCPA. For we had for an violation that's uncured, and CDPA does not include a private right action against. And there's, however, you must notice that a lot of uh, rights, a lot of obligations, and have been borrowed from the CCPA, but there are a few differences. and a lot of work ahead for organizations to update their privacy policies, vendor agreements, develop or modify the mechanisms for data subject access requests, and reassess products, systems, and services as well. So a lot of work that needs to be done, but the good news is that there is uh, sufficient time uh, at our hands to kind of do a thorough job at it. So right, so um, some of the um, other states, if you look at this map here, you would see that it's updated one, and the date of updation was 22nd March 2021. The ones highlighted in red, California and Virginia, have already signed the bill, and companies are now trying to look at how to kind of comply to the Virginia CDPA, as well as the CCPA 2.0 or CPRA, which is again in kind of a modification to CCPA, and kind of trying to understand how to do a good job at it. There are a lot of uh, bills in the cross chamber or in committee, or being introduced. So this map, it kindly demonstrates that there is a privacy wave, and it's not going to stop. It's going to, it looks like it's going to continue for a long time. And a very good initiative by different states to kind of take care, or be considerate of their residents, and enforce those kind of privacy um, laws, so that they have the residents' best interests at heart. So um, a tabular kind of representation here of the state and the effective date, right, for for some of the next ones, which is New York, Washington, Florida, Kentucky. A lot of these states are kind of uh, there's an effective date to it, and it's soon approaching. So one very important tip at this point I'd like to share is that it's good to have a privacy by design, which is more of a proactive approach, rather than a reactive approach to each of these states, so that it's not a start from scratch activity each time, but more of those 20%, 30% modifications which are required with every passing law, right? So that's a very good way of kind of handling these privacy laws as they come up. All right, so now is a very good time to discuss some best practice guidelines, and we have learned a lot through our implementation work with some companies for CCPA and GDPR, and we would want to share this with all the attendees here, so that even if you have some questions, please feel free to kind of enter those questions in the chat window, and we will definitely discuss it towards the end of the webinar, right? So just a gentle reminder on that as well. So let's go through these best practice guidelines. So the first one is leadership and multidisciplinary collaboration. So I mean, can't stress enough on this point. Executive support and multidisciplinary team is essential to a successful implementation. And the requirements imposed by the CDPA are similarly to extensive to be addressed with paper policy changes alone, right? And too complex for individual business units to develop kind of those siloed or isolated compliance approaches. right? So, while the effort is a response to a new law, the process for achieving compliance with CDPA should not be viewed or managed solely as a legal undertaking, right? It's a team effort, it's a collective responsibility, and determining response ownership within the organization and acquiring resources from multiple groups within the organization to kind of successfully implement the CDPA will be a significant effort as we know it. And most successful and compliance efforts are, the effort or the product of a strong leader, situated appropriately within an organization. So, it's very vital that this person should have a clear mandate from the executive suite in order to avoid being perceived solely as a compliance, IT, or legal functionary, without the appropriate organizational support to execute on a large and diverse project. Uh, Budgeting for the extensive efforts required to comply with the GDPR and CCPA was a bit of a hot potato for many companies. The impact of this compliance effort within organizations was wide ranging, right? So while the budgeting allocations for the CDPA effort will necessarily be specific to each organization, the lessons that we learned was that it's better to tackle the budgetary issue sooner than later, so that the implementation effort is not derailed or delayed by internal conflicts. So there is no time to waste, as most organizations will now take time to assess and implement the many likely IT and business process changes, right, required by January 1st, 2023, right? So although there's still time, but it's better to kind of uh, have things planned out and budgeted out as early as possible, so that implementation is streamlined, and there's a proper methodology to this implementation. Well, one of my favorite points here, uh, one of the most important pieces here is to have a good data inventory and mapping, to kind of streamline those compliance efforts. And although it's extremely time consuming, we saw this with the CCPA as well, and GDPR as well, that companies will require to track data of Virginia residents within their enterprise, provide information about the data to those residents, and track and control the disposition and use of the data within and outside their organization. So, while the size and complexity of an organization and the extent of its reliance on consumer data you know, will impact the difficulty entailed in this task, a comprehensive data map and inventory is very, very, very important, right? Because, and it's not a paper process. There are tools out there that can assist with the identification and the mapping process. However, it will require significant investment of person hours, management energy, and knowledge of the company's data practices and the underlying compliance requirements to render effective results, right? The point of this exercise is to understand what uh, personal information resides within the organization, its sources, uses, the internal and external systems that process it. You know, uh, Kind of painful and time consuming to generate, but again, a well drafted or a well crafted uh, data inventory can serve multiple purposes. Not It provides the initial layout or the foundational understanding of the compliance effort, but it also helps to demonstrate and track compliance on an ongoing basis as well, right? So very important to have a data inventory and map ready. Um, So you have the time now, we can start to kind of get the vendor management work stream early on in the compliance effort. uh, you know as the data mapping process will reveal in great detail that most organizations rely on a vast network of third party relationships, ranging from service providers, marketing partnerships, and co-branded relationships, data brokers and others. So, similar to GDPR, the CCPA similar to GDPR and CCPA. The CDPA will require organizations to identify third parties with whom personal information is shared, disclosed, or sold, and in some cases to pass along consumer requests, regarding the data to such third parties, or otherwise coordinate with third parties about notices, opt-outs, and consumer data, data rights. So identifying these relationships and determining, how to address the compliance requirements will be a significant challenge for sure. One that is more complicated, given the inherent dependency on third parties, and many with little incentive to engage in the process, right? So given these challenges and dependencies, it's crucial to allocate sufficient time in compliance effort to assess these relationships, develop a compliance approach for both new and existing third party relationships, and then go on to implement that approach for an on an ongoing basis, right? So very necessary to have the management charted out as early as possible.
Thank you for listening. And now, we have received a couple of questions on the chat window. So let's, go through them one by one. Right. The first question we got today was, if my company is compliant with the CCPA, will we be compliant with the CDPA? Right. So, well, CCPA compliance is a good start towards CDPA compliance, but given the differences between the two laws, there may be some slight modifications which will be required. We spoke about early on. We spoke about processing of sensitive personal data, or we spoke about data protection assessments. Uh, we also spoke about the privacy policy which needs to undergo a change. So these minor modifications need to be made, and so that will uh, kind of help comply to both the CCPA and the CDPA. But it's also important to keep an eye on the other laws that will be passed, right? And how what states, what are different states planning on, so that we have a good privacy by design kind of an approach, which is more proactive and can easily accommodate those different laws as they come up. So that's an important pointer, right? The second question we got was, can Consumer Data Protection Act apply to me if I am not a consumer facing business? Well, as it stands, it applies to consumer facing businesses only, right? And we did cover some of the exemptions or exclusions which were granted by the CDPA in our session earlier today. But it does also exclude sole proprietors, for example, the ones who are acting in their business capacity. So there are those exclusions as well. But to answer your question, well, it just is for consumer facing business only. It does not apply to B2B. So uh, that's that wraps up the uh, questions that we received today. So here on the screen you can see the email, which is info@royalcyber.com. So if you have any questions or you'd want to connect with us, feel free to reach out to us or send us an email, and we'll make sure that we promptly respond to those requests or questions and as we get them. Once again, thank you so much for your patient hearing today, and uh, have a good rest of the day. Thank you.